This is a story about a woman we'll call Mary Johnson. She's asked us not to use her real name because she's involved in a legal battle that will likely leave you shaking your head. Several years ago, Mary went to the doctor. She was billed $294 for the visit, but says she never got a bill and quickly forgot about the trip. That bill ended up at Medical Recovery Services, a debt collection company based in Idaho Falls. Attorneys Brian Smith and Brian Zollinger handle cases for the company. Fast forward to early last year. Mary works at Melaleuca, and Medical Recovery Services sent a garnishment notice to her employer requesting nearly $1,000 for the $294 bill. The additional money was for interest and attorney's fees. But there was one problem.
Melaleuca received a garnishment document that didn't match any name of an employee, and Melaleuca couldn't guess, and potentially guess wrongly, as to who the true judgment debtor was.
The Social Security number on the garnishment was Mary's, but the last name did not match hers. According to legal documents, Melaleuca attorney Andrew Law called Medical Recovery Services on June 20th, then followed up with an email writing, "I indicated that Melaleuca is willing to work with you and that Melaleuca doesn't believe it is necessary to take this dispute to the court." Melaleuca's proposal to Smith was simple. Send us a legal request called an interrogatory asking us to tell you the name of the employee with the Social Security number. But Smith refused, and 1 month later, he and Melaleuca attorneys went before Magistrate Judge Michelle Mallard.
We're here today, Your Honor, because plaintiffs have not been careful in how they pursued their garnishment efforts in this case. First, plaintiff did not carefully ensure that its garnishment documents accurately named a Melaleuca employee. Melaleuca invited plaintiff to propose a solution that is less burdensome than a notice and deposition and a subpoena to produce documents. That solution could have consisted of a simple discovery request, but plaintiff chose not to take Melaleuca up on that invitation.
What we have here, Your Honor, is a misunderstanding by Melaleuca, and it may be because they don't do this kind of work. I can understand that. Few people do it. They completely get the statutes wrong, and I'll show the court how that's the case. I don't blame them. I don't talk about their negligent work not doing it right. They just don't have the statutes right. I don't know why they're making such a big deal out of this.
Maybe it doesn't appear to them that their employee is the same person and that has been using their employee's social security number, and they don't want their employee to be subjected to these actions of someone who may have already taken her identity.
It's all rank speculation. We don't know, but we're going to get to the bottom of it.
They got to the bottom of it. Judge Mallard ruled that Melaleuca's response to the garnishment was true and sufficient. She discharged the company of any liability and told Smith that he could ask Melaleuca to tell him the name of the employee, something the wellness company had already offered to do. Court documents show Smith sent an interrogatory, learned the employee's name, garnished her wages, and obtained over $1,200, nearly $1,000 more than the original bill. So case is closed, right? Not so fast. Last month, Smith filed an application for award of supplemental attorney's fees. That's legal talk, meaning he wants someone to pay for the time he spent on Mary's case. The amount he wants, $5,583.25, nearly 20 times more than the original medical bill. And who does he think should pay those fees? Mary Johnson. Of course, we wanted to ask Brian Smith about this. He was too busy for an on-camera interview, but did speak with me on the phone. Why should she have to pay for that?
It's real simple. Under the law, we get to ask the court for what's called post-judgment attorney's fees for the work we had to do after the judgment to satisfy the judgment.
But it's not her fault. All of this was not her fault.
I understand that, but it's not based on fault.
But is it right?
But it is kind of her fault because she could have come in and made payments. She didn't do it.
But
she could have told the lawyers at Melaleuca, "Don't fight this guy because I don't want to have to pay anything."
But did she know? That's the question. Did she know that this was?
Who should have told her? Who should have told her?
Well, shouldn't
Melaleuca attorney should have said that to her?
Shouldn't, but if the name had been correct 100%, then it would have happened. I imagine they would have garnished her wages because then that would.
That's correct. Well, no. Okay, look, because Melaleuca wouldn't have taken this position, but when it didn't match, let him take the garnishment. That's what he should have done.
So why didn't you just go to the employee and say, is this you?
Debt collectors have a duty to ensure that they know the true identity of the debtor. Employers don't have that duty, and employers can't guess lest they expose themselves to potential liability and problems with the employee.
Law says Melaleuca has responded to garnishment requests from medical recovery services in the past without any problems, and the company will continue to do so. Even though the judge ruled against Smith, he stands by his actions. Do you think that your firm did anything wrong in this case?
Absolutely not.
And Smith believes Mary should pay him over $5,500 for the time he says he spent on the case. Is there anything that Melaleuca plans to do to help this employee with the situation?
Melaleuca believes that turning a few $100 debt into more than $5,000 in attorney fees is simply unreasonable. And for that reason, Melaleuca has worked with the judgment debtor in this case to help her secure competent counsel so she can defend herself.
The next court hearing between Smith and the Melaleuca employee is April 22nd. We'll be there to let you know what happens. Now, this is just one of many, many cases that Medical Recovery Services has been involved in over the years. Tomorrow on EastIdahoNews.com, meet a man who was sued by the company over a mistake his doctor made. He fought all the way to the Supreme Court and won. I'm Nate Eaton, EastIdahoNews.com.